Someone brought to my attention a little matter about Winston Charles James, the man who was in the car accident that caused the death of Johnnie Jacobs. I'm not going to name the person who told me, but if she wants to name herself in the comments, please give her the kudos she deserves. For those of you who aren't aware of who Johnnie Jacobs is, he is the one who found Micah Francis's belongings on the day she died. And if you don't know who Micah Francis is, you can find a playlist about her case in the description box. Okay, now that we have that out of the way, Winston, or as I like to call him, Winnie, had a lawsuit filed against him in Kings County Supreme Court in New York. The suit was filed by a man named Sukrab Zainab, and I guess if Winston's going to be Winnie, Sukrab should be Suki. And why did Suki sue Winnie? Well, let's have a look at the court documents, and I might paraphrase some of them because boring. On March 5, 2019, Suki filed the following complaint. And it starts with, first, that at all times hereinafter mentioned, the plaintiff was, and still is a resident of the County of Kings, City and State of New York. Second, that at all the times hereinafter mentioned, defendant Winston Charles James was the registered owner of a certain motor vehicle bearing license plate number redacted for the state of Virginia for the year 2018. Third, that at all the times hereinafter mentioned, defendant Winston Charles James was the title owner of a certain motor vehicle bearing license plate number redacted for the state of Virginia for the year 2018. Fourth, upon information and belief that at all the times hereinafter mentioned, defendant Winston Charles James was the operator of the aforesaid motor vehicle. Fifth, upon information and belief that at all the times herein mentioned, defendant Winston Charles James maintained the aforesaid motor vehicle. Sixth, upon information and belief that at all the times hereinafter mentioned, defendant Winston Charles James controlled the aforesaid motor vehicle. Seventh, that at all the times hereinafter mentioned, President Street and at or near 1563 President Street, County of Kings, City and State of New York was and still is a public street and highway. Eighth, that on or about the 5th day of November 2018, plaintiff was lawfully operating his motor vehicle at the aforesaid location. Ninth, that at the aforesaid time and place, the defendant's motor vehicle came into contact with the motor vehicle of the plaintiff. 10th, that as a result thereof, this plaintiff was caused to sustain a serious injury, as defined under 5102D of the insurance law of the state of New York, or economic loss greater than basic economic loss, as defined in 5102A of the insurance law. 11th, that the said occurrence and serious injury sustained by this plaintiff were occasioned through the negligence of defendant in causing and permitting his motor vehicle to be operated in a negligent and dangerous manner, in failing and omitting to have his motor vehicle under reasonable and proper control, and carelessly and negligently causing and permitting his motor vehicle to be operated over and along a public highway at a high and or excessive rate of speed and or a greater rate of speed than care and caution would permit under the circumstances then and there existing, in failing to be properly alert, in failing to keep a proper lookout, and to see what was there to be seen, and failing to make proper, prompt, and efficient use of adequate brakes and steering mechanisms, and failing to obey traffic signs and signals at the intersection, and failing to properly maintain and equip his motor vehicle, and causing, permitting, and allowing his motor vehicle to strike and collide with the motor vehicle of the plaintiff, and failing to take those steps necessary to avoid the accident herein, and failing to slow down and or stop at the intersection, and failing to observe the conditions of traffic then and there prevailing, and operating his motor vehicle without regard to the traffic then present on the said thoroughfare, and failing to bring his motor vehicle to a proper stop so as to avoid contact with the plaintiff's motor vehicle, and failing to sound a warning or give any other sign by horn or otherwise of his approach or of the impending accident, and following the plaintiff's vehicle too closely, and failing to operate said vehicle in his proper lane of traffic, and negligently changing lanes, and making an improper lane change, and negligently turning, and making an unsafe turn, and in failing to slow down the vehicle in order to take cognizance of other vehicles at or near the intersection prior to entering into the intersection. Whew! If you ever need to describe a car accident using as many words as possible, just plagiarize that. 12th, that by reason of the premises as aforesaid, this plaintiff was rendered sick, sore, lame, and disabled, and his injuries upon information and belief are of a permanent character. that by reason thereof he has been prevented from following his usual vocation and has been obliged to incur expense and obligations for medicines, medical care, attention, and treatment, and he is informed, and he verily believes, that he will, in the future, be obliged to incur expense and obligations for medicines, medical care, attention and treatment, and continuous pain and suffering, and be unable to follow his current vocation, all to his damage, in an amount which exceeds the jurisdictional limits of all lower courts. And the rest of it is just explaining what he wants. And it's basically that he wants a monetary amount which exceeds the jurisdictional limits of all the lower courts. And he wants money to pay for everything involved in the accident and all of his medical bills. On May 16th, Winnie's attorney filed an answer. And the first part is just a denial of everything that was written in the complaint. And then he added this. Any damages sustained by the plaintiff were caused by the culpable conduct of the plaintiff, including contributory negligence or assumption of risk, and not by the culpable conduct or negligence of this answering defendant. Upon information and belief, plaintiff failed to use or misused seatbelts and thereby contributed to the alleged injuries. And the answer further alleged that the court lacks jurisdiction over the person of the defendant, Winston Charles James, by reason of the non-service of the summons upon the defendant, Winston Charles James, either personally or by substituted service. That to the extent plaintiff recovers any damages for the cost of medical care, dental care, custodial care, or rehabilitation services, loss of earnings, and/or economic loss, the amount of the award shall be reduced by the sum total of all collateral reimbursements from whatever source, whether it be insurance, Social Security payments, no-fault payments, workers' compensation, employee benefits, or other such programs, in accordance with the provisions of the CPLR 4545. In the event that any person or entity liable or claimed to be liable for the injury alleged in this action has been given or may hereafter be given a release or covenant not to sue, defendant will be entitled to protection under General Obligations Law 15108 and the corresponding reduction of any damages which may be determined to be due against this answering defendant. Wherefore, this answering defendant demands judgment dismissing the complaint herein with cost. The court sent a preliminary conference order that stipulated what Winnie and Suki needed to do. And it seems as though the boys didn't comply because the court sent another order and mentioned that they were a little more serious about it. And then the court sent another order, and this time the judge gave deadlines. In May of 2023, Suki's attorneys then filed a notice that they wanted a jury trial. Then the case sat there until September of 2025, when it was dismissed with prejudice, meaning that the lawsuit can't be filed again. I wasn't able to find any record where either of the men were issued a ticket for this accident, and wasn't able to find a police report for the accident, so I'm not really sure what happened. I know there are those who want to believe that Winnie purposely killed Johnnie Jacobs because John Paul Miller had contracted him to do so, but I don't think that's what happened. I think Winnie just can't drive for Dookie. I think when he hit Johnnie, he was driving too fast and missed the stop sign. I just can't see someone being a hitman that uses a vehicle as his weapon of choice, much less one who uses a Mercedes, which is what he was driving when he hit Johnnie, who was in a truck. Winnie's attorney wasn't wrong when he said that Suki might have fared better in the accident had he been wearing a seatbelt. Likewise, Johnnie Jacobs might still be alive had he been wearing his. I'll be back soon with more true crime. Until then, stay safe, stay curious, and buckle up for safety, kids.